Georgia's transfer upon death deed. Let's talk about that. Georgia recently passed a law that allows for a transfer upon death deed to avoid probate when it comes to real estate. Why is that important? Well, let me give you an example of what life was before this law was passed. Prior to this law being passed, there were only two ways you could avoid probate when it comes to real estate. One would be creating a trust, and some people may not have enough money to go about creating a trust, so that might not be an option. The second way is while you're alive, if you add your child onto your deed with rights of survivorship. If it says rights of survivorship on that deed, you do not have to take that house through probate. However, there are huge capital gains ramifications that you may leave your child with, and you don't realize that you're making this mistake because you're just trying to avoid probate. Watch this video to learn more about why it might not be a good idea to add somebody to your deed while you are alive here in Georgia. Now let's talk about finances, because they've kind of had this in place for a while. Whether you have a bank account or a 401k, an IRA, a Roth IRA, a brokerage account, you get the idea. You can take your beneficiary form on those accounts and name who your beneficiary is when you pass away, and that automatically goes to those individuals without having to go through probate. So this is a good thing, because if your house does have to go through probate, at the very least your loved ones can get a hold of those assets and be able to start utilizing them to get the house ready to sell. Now, let's circle back around and talk about these transfer upon death deeds, because prior to the law being passed, whether you had a will or not, the property was forced to go through probate. Now with this transfer upon death deed, you can name a beneficiary. You do have to go file the deed at the courthouse so it's on record. And if something happens to your beneficiary, maybe they turned out to be a difficult person, or maybe they become incapacitated and can't really do things for themselves anymore, or maybe they pass away, you can go and revoke the transfer upon death deed. Again, you have to go to the courthouse and get it canceled. One other tiny little nuance you need to be aware of. After you pass away, your beneficiary has 9 months to go to the courthouse and to get that deed officially transferred into their name. It is not automatic. So if your beneficiary waits 9 months plus 1 day, the house is going to have to go through probate. So here's my disclaimer. I'm not a financial advisor, a CPA, or an attorney. So if you need guidance when it comes to doing these transfer upon death deeds, or you want to understand capital gains ramifications and how your finances could potentially be passed on to your loved one, you need to seek out those professionals. I am a certified probate real estate agent. So there you go. If you need help, whether it's selling a house that is in probate or you're just trying to sell a house, I can help you in the greater Atlanta area. And if you're in other parts of Georgia, I can connect you to a good agent in your neck of the woods. I hope this helped y'all out. See y'all later. Bye. Are you digging the kind of content I'm producing? Then be sure to watch this next video. And don't forget to subscribe to my channel. That way, you'll be in the know when I release my next video.